welcome back. Let's take you to this now. South Africa's labour laws could soon undergo one of their biggest changes in more than a decade, and the reforms could reshape how millions of people work. Following the publication of the proposed amendments in the Government Gazette on the 26th of February, government is proposing significant changes to the Labour Relations Act and the Basic Conditions of Employment Act. Now, the proposals include doubling retrenchment pay, extending protections to gig workers, and introducing what government describes as a more equitable maternity leave system. However, the reforms have also raised concerns that they could make it easier for employers to dismiss workers while allowing new small businesses to be exempt from bargaining council agreements for 2 years. Now, the discussion is particularly important as more South Africans enter the gig economy through e-hailing, delivery platforms and freelance digital work, sectors that have often fallen outside of traditional labour protections. Well, to unpack what these proposed changes could mean for workers and businesses, we're now joined via Teams by labour consultant John Botha from Global Business Solutions, as well as advocate Vusi Masinga from Trade Union UASA. Very good afternoon to you, gentlemen, and thank you so much for your time. Perhaps let's start with you, Mr. Botha. You know, from a labour law perspective, how significant are these proposed amendments, to South Africa's employment legislation? Perhaps also just highlight some of the key, proposals here.
Good day to you and the viewers. It certainly is a big step towards regulating the modernized workforce. As you indicated, gig workers, last mile delivery. If you look at Take-A-Lot, you look at Checker 60, those types of workers, Uber, they've been under the spotlight for some time. And what you now see as part of the amendments is to look at expanding the definition of employee to potentially start addressing these particular individuals, because sometimes there's a very fine line between these individuals being contractors and between them being employees. And what we've seen to date primarily is they are treated as contractors. So these individuals are paid per delivery. They are often required to rent their vehicles, and they're being treated as contractors. But depending on the structure of that particular model, they could very well now fall within the ambit of the employment relationship, which really means it has a massive impact on these operating models from a cost point of view, as well as from a contracting point of view. I mean, imagine bringing, hundreds of thousands of people into the world of UIF, workman's comp, PAYE, where currently they are largely excluded from that. So it's not a small matter. There are certain procedures like sectoral determinations that would have to first be put in place, but it is definitely a start in regulating that. Thank you.
Yeah. Advocate, let me bring you in. So we've talked about what some of the proposals are, including, of course, doubling retrenchment pay, extending protections to gig workers, introducing what government describes as more equitable maternity leave system. From face value, it does look quite positive, but of course there are those concerns about, how easier for employers it could be to dismiss workers, as an example. From the perspective of workers and organized labor, how do you view these proposed amendments to South Africa's labor laws?
Well, thank you so much, ma'am, and thank you so much to the viewers, and also thanks to the contribution of Mr. Botha there. Ma'am, each and every time the amendments are made, they are influenced by quite a number of things, things such as the court judgments, as you have seen in the most recent judgment of Van Wyk. Now, starting with the doubling of the retrenchment pay, that seemed to be a very good effort on the side of Parliament. That is welcome. But we all know that whenever changes like these ones that benefit employees, come into effect, they also create other work employment related challenges, leading to employees being dismissed for reasons that are not valid at all in the form of a retrenchment. Now, we really welcome that, and honestly speaking, that will be very much beneficial. Now, as we know that traditionally, or in terms of the current law, the pay for a retrenchment, which is the severance pay, it is only limited to 1 week of each and every year that has been worked by an employee. Now, such a change is welcome by labor. Now, when it comes to the gig workers, each and every employee deserves protection from government. Now, as you know and understand that from labor side, we have always been serious, when it comes to the protection of the proletariat, which is the working class. Now, previously, these type of employees or category of employees, they were not even protected. Now, when you look at the current changes, they are trying to make employers account. As you know, that the basic conditions of employment advocates for employees to have particulars of employment, in this case, the contracts. Now, the employers are being made to account by making sure that these employees, that we could also say they were marginalized, they have their contracts, wherein in their contracts, it is agreed in things such as the working period, the hours of work, if they are called to work and then there is a cancellation, the employer needs to account for such a cancellation. Now, when it comes to the maternity system, that is also welcome. Now, as it stands, we all know that the 2019 amendments came with significant changes which allowed parents in the form of fathers to also benefit from a 10 days leave. Now, this time around, which was the significant judgment of Van Wyk, it is striking the balance in making sure that both parents, they are actually treated equally, which was the main basis of the judgment that Section 25, Section 25A, Section 25B and C, those sections of the BCEA must be invalidated due to the problems that they created in as far as equality is concerned.
Yeah. Mr. Botha, I want to talk about something that you've also mentioned, of course, that, that the reforms could modernize the labor system. And you've gone on to, give some examples of the kind of employment that we're talking about here. From your experience advising businesses, I mean, what would this mean and what would this look like in practical terms, particularly for employers as well as employees, especially when you hear, those concerns that in some introductions like gig workers, it could make it very easier for employers or employers rather to dismiss employees. I mean, this surely could also come as a concern.
Yes, the amendments to the law are trying to achieve what I would call regulated flexibility. So as we move deeper into the fourth industrial revolution and you have these new forms of work emerging, the right to human dignity, the right to be protected is very important. But at the same time, there is a clear distinction between someone who's a contractor and who's working for their own account and someone who's being employed. And what I believe these laws are going to do is they're going to force organizations who've been using platform workers to go and reevaluate and make sure they're not running too close to the line. I think that's the one thing. So it's going to require organizations to do a due diligence, and to either opt for a clear employment relationship, alternatively, to properly outsource that. I think the second issue, maybe just as a comment, because it's a concern of some of the trade unions, and Advocate Masinga may be alluding to that, is the issue around probation. The proposed amendments are that organizations can employ someone on probation and potentially dismiss them without following the rigorous procedures that currently exist. The only exception would be if it's dismissal on race, sex, sexual orientation, and the like. So on the one hand, we see the legislative amendments trying to encourage employment, exempting small companies for up to 2 years from very, very onerous bargaining council minimum wages, etc., just to get momentum. But on the other hand, there's no doubt in my mind that there's a need to be very clear on how to regulate workers who are potentially employees and who are not benefiting from the protection of law.
Yeah. And Mr. Advocate Masinga, perhaps also your response to what Mr. Botha has said, and perhaps also add to that, to those concerns and what employees should be looking out for. What should ordinary workers in the coming days particularly be paying close attention to, especially as these amendments move through that legislative processes? What advice would you then give to workers to pay very close attention to, particularly also those that are going to receive contracts following, of course, those important decisions that would then be tabled?
Well, ma'am, honestly speaking, starting with the area that Mr. John alluded to, the 3 months probation, that actually causes a huge problem for labor and the employees. Now, as it stands, we have quite a number of cases that we are handling, cases that deal with dismissal, while the employee is still under probation. Some of them, they are dismissed before even the 3 months probation is actually completed. Some of them, after the probation period has been completed, they are told that no, unfortunately, we will not be able to give you the permanent employment. Now, it seems like now, on top of the existing problems, government is adding more problems on that instead of protecting employees. A probation period is a period that is used for the employer and employee to be able to see whether there can be a working relationship between the two of them, where the employee has not yet adjusted to the culture or meeting the standards that are required by the employer. Now, what we have been seeing from those honest employers, they would extend the period of probation for such an employee to make sure that that employee actually adjusts to the required standards of performance and work. Now, with the changes, the advice I can give to the employees is that they need to pay attention. They need to pay attention. They need to know that the protection that is afforded to them is only minimal. There's only it can actually be classified as being minimal to none. That's basically what I can say. And the advice I can give them. Yeah.
All right, essentially, people should really be paying close attention to this. Gentlemen, thank you so much for your time. Really do appreciate it. That's a Labour consultant, John Botha, as well as from Global Business Solutions, as well as Advocate Vusi Masinga from Trade Union UASA, of course, speaking there about those proposed amendments in the Government Gazette on the 26th of February, government proposing significant changes to the Labour Relations Act, as well as the Basic Conditions of Employment Act. All right, you're watching Week in Review here on the SABC News channel. Stay with us. We will be back at the top of the hour, the final hour after the break. Stay with us.